Lawrence,
Yes.
Esther Lynn, Justice Macy-Walla,
Yes.
Bethany Peak, Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson.
Yes.
We have a quorum.
Thank you, Devin. Now we can talk about ad standard. I didn't mean to cut you off, Mr. Kramer, regarding University of Laverne. So do we want to discuss that agenda item now?
I think since we pulled it off consent, we need to discuss it and have the vote.
Right.
Well, could we put it back on consent? Because I withdraw my withdrawal of it from consent.
I
think we can.
We already voted on the consent calendar.
It's already been pulled. What I would recommend is just calling it, doing an abbreviated report, and if there's no discussion, you guys can proceed with the vote.
Okay, let me do it real quick, Natalie. So Laverne wants to permission to allow some graduates under specific circumstances, or some people to graduate under specific circumstances in 2.5 instead of 3 years. They would be accelerating their classes by adding a unit during the semesters and then taking summer classes. With the changes that were posted on Wednesday in the report, I recommend its approval.
Any additional comments or questions? Hearing none, I need someone to make a motion.
I'll make the motion to approve. Alan?
Anyone second? Thank you, Mr. Yokelson. Anyone second?
Just both. Second.
Thank you, Dr. Bolton. Any additional discussion or debate? Hearing none, Devin, please take the roll.
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora, Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, Justice Macy-Walla,
Yes.
Bethany Peak, Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan.
Yes.
With 11 yeses and 0 nos, the motion passes.
Thank you, Devin. We're now on item number 4, specifically agenda item 4.1, action on revisions to the admissions rules and guidelines pertaining to examination conduct violation.
Did you want to do the second ed standards item? Or we can, it doesn't matter. We can go back and forth if you want.
I don't have a preference. If Audrey, you feel like we should, we can.
No, it would only be thematic, but we can we can go back and forth.
Well, I already announced agenda item 4.1, so let's just get, yeah. Amy, I believe you have a report for us.
Yes, I do. Audrey is going to pull up the PowerPoint.
Sure, you want me to share that now?
Yes, please. Thank you. So I'm bringing 2 things to the committee, 2 points of discussion. And one is staff have made some recommended changes to the matrix that I'll dive into. And then also feedback on the rules changes. And this is specific to the decision or an approved set of proposed rules related to Chapter 6 from December 2023. So let's start with this discussion. I want to talk about, remind everybody and remind the committee about why staff initiated a rules review. These were the considerations and areas that we wanted to tackle. We wanted to address any contradictions between the rule, a statute, and state bar rule, clarifying any ambiguity experienced by staff or by applicants in our rules, to revise a rule with an eye towards access and fairness. Do any unnecessary hurdles exist within the rules? Do the current rules further public protection and consumer protection? So just to remind everybody, in December of 2023, the committee approved a set of rules, rule proposals that were going to go to the Board of Trustees for a request to circulate for public comment for a 60-day period. Since that last December, the rules have been reviewed once more by Office of General Counsel, by staff. We had a volunteer member of the CBE. And this period has afforded an opportunity to look at the rules with the changes taking place in exam administration in mind. So we've been able to reevaluate the rules, given that we're going to host a hybrid exam. And so the rules need to address the needs, the security needs of both a remotely administered exam and an in-person exam that's taking place at vendor-run test sites. So that's what the lens that we applied in this next review. Next slide, please. And so we consulted, as I mentioned, the staff consulted on this, the committee of bar examiners, CBE volunteer group is the group that brought recommendations to the committee in December. We had the new attorney that's assigned to work on the state bar rules, as well as a volunteer in this year. So let's talk about what took place. So in the decisions that were made in 2023, the packet of rules that were approved did three things. So they changed the matrix specifically to loosen the rules around water and religious headwear. So applicants, people could bring water. It was removed from the list of prohibited items. And also applicants are no longer required to submit requests to wear religious headwear. So that is now a permitted item. We also added altering and answer files after time is called to the matrix. And then and the guidelines were modified to reflect those changes in the matrix. And so those were approved. And given that the matrix is overseen by the committee, these changes were made. They did not have to go into the rules that required that they go to the board, and they also have to be considered, excuse me, they also have to be go through public comment. The other rule changes that occurred and that were approved in 2023 included clarification, language clarification. So some of the clarifications included adding specificity to conduct that violates security integrity. Also to distinguish between disputable and indisputable violations. And so that was incorporated. Also, we discontinued the practice of holding someone's grade in abeyance, or that's the intent here, so that people would receive their grades as they are prior to results release, so that they would be aware and they'd have the opportunity to also register for the next exam if they were unsuccessful as a result of this, of the violation or the sanction. We also eliminated the administrative hearing. And the goal there and the intent was to reduce the time that it takes to come to a resolution for applicants. And so in this model, staff would make the initial determination, the hearing would be handled by the committee of bar examiners, and applicants would still have the right to appeal to the Supreme Court after bringing it to the after the administrative hearing and bringing it to the CBE. And so that's what happened in 2023. And now that the bar exam is going to be administered remotely, and like I mentioned, also at vendor-run test centers, starting in February 2025, we're proposing additional revisions to the Chapter 6 matrix to reflect this new modality. And there are three separate areas that we are suggesting changes in the matrix. One is related to the security check-in procedures. So right now, our exam vendor, Measured Learning, requires remote examinees to conduct a 360-degree scan of the testing space using the computer's camera, but also including viewing under their desk And applicants, as a result, are required to use their cell phone or a reflective surface like a mirror to show the area behind their camera. And so currently, the Chapter 6 matrix strictly prohibits the possession of any electronic devices, especially cell phones, for security purposes. And so we're proposing to modify the language that will let people know that, or let applicants know that except for the presentation during the security check-in process, that possession of a cell phone or other electronic devices is strictly prohibited, so that we would not erroneously note somebody as in violation when in fact they're adhering to the check-in procedures that are required of our new vendor. The next item that area that we'd like to address is clarifying the applicability of the matrix to all examinations. So we're proposing to remove references in the guidelines to the first-year law student exam and the California bar exam, and replacing that with all exams administered by the State Bar of California. And this is for us to be able to apply those rules even to our study participants that participated in the California bar experiment.
Amy, let me stop you there. I
Sure.
believe the draft says administered by the Office of Admissions. So do you mean this to include, I guess, the legal specialization exams?
Yes, I think that we are preparing in the event that it's an item that will be coming to the board, to the CBE shortly, but the idea is there's a potential that the CBLS will cease and sunset, and as a result, some of those examination appeals or examination cases or considerations will come to the CBE is one of the proposals on the table.
Okay, so I think we'll need to fix the draft when we come to it.
Sure. Okay. So the last item, this last set of changes to the matrix include removing irrelevant policies or procedures in the matrix. So right now, for example, we have one of the violations includes applicants who fail to upload their exam responses in a timely fashion are sanctioned with point deductions. That is no longer going to be the case or feasible, given that our vendor now does live proctoring, so there's no need to upload an exam response. And so we think it'd be in the best interest of our applicants, so as not to confuse them, to remove this from the matrix. And so,
Can I stop you there again? I don't see the connection between live proctoring and the need to upload.
oh, okay, I can make that for you. So in live proctoring, people log on to a platform, and so that platform opens the application, so you're accessing the questions and the portal where you enter your material, which is called the test driver. So you enter that data, that portal opens and it closes because you're working with the live proctor. In the other model, which we had when we used ExamSoft, applicants basically downloaded that software. And so when they came to the exam, we gave them the hard copy version of the questions. They loaded their questions when the internet, without needing internet. And when they came close to an internet, those questions would upload to ExamSoft. And so with live proctoring, that is not necessary.
So then with the new system, they're typing basically into a web page that uploads their response immediately or at periodic intervals. And rather than storing the document as they modify it on their local computer. And so because it's already up on the website, there's no need to upload your local copy, which doesn't exist anymore.
Correct. Mm-hmm.
Okay.
All right.
Yeah, I didn't get
So-
that either. Amy,
Okay.
that will also eliminate the problem or the disputes people have about they tried to upload it later, late uploading.
Yes,
Because we just won't have that issue anymore.
not at all. No, we won't. Okay. Well, and one thing I want to recognize here is that these three changes do not require board approval and are time sensitive because, as I mentioned, we need to be able to, with the phase 1 of the California Bar exam experiment being completed, we need to be able to act on some of these items. Okay, so.
By the way, if I remember correctly, I thought for a while now, if the applicant uploads the exam late, I mean, there's still a timestamp for modification, meaning that the file was modified. The exam administration would know that it's been modified. So even if the exam was uploaded late, there is a way to determine whether the file was in fact modified. Is that still sort of the option? Meaning, are there still two separate timestamps noting when it was uploaded versus when it was modified?
Yes, so we have a report that distinguishes those two things. So
Right.
what point was it
Perfect.
uploaded? At what point were any characters changed in the document or added?
Yeah, I know we may be talking about this later today, but I understand that some concerns relating to uploading the file, there are instances where maybe the file was not uploaded correctly, or there might be other internet or related connectivity issues. And so I think we, as a committee, probably will need to address, whether we could potentially give those candidates some leeway, provided that, the file is not modified. Anyway, I just wanted to confirm that we still have those two timestamps as part of the ongoing consideration of this issue.
Yes. Okay.
Good stuff.
All right. Great. All right. So then the rule change that we're bringing back here is a modification. So I mentioned that one of the rule changes included replacing a staff-led administrative panel to a 3-member panel comprised of members of the CBE. And so with eliminating, these are the steps that we would take. Eliminating the administrative panel, the steps that would happen is that staff would make the initial determination. The administrative hearing would be handled by the CBE at the next regularly scheduled meeting, and an applicant would be notified about with the 3-member panel determination. So in a recent conversation with a CBE member, we talked about they've added this a proposal to change this process so that the same 3 initial steps would take place. However, that the 3-member panel would bring a recommendation to the full committee at the next regularly scheduled meeting, and the committee would have the option at that point to either approve, deny, or modify that recommendation, and then the applicant would be notified of the full committee's determination. And so can we go to the next slide? I want to highlight, and I'm sorry that this font is small. I just wanted to make sure that I included all the notes. So what this looks like in terms of the life cycle for a case. So as you can see here.
Maybe I don't have any slide. I don't know if you meant to share that with the committee. Nothing's being.
It's not up there?
I can see it.
You not see my screen anymore?
Am I the only one?
I can see it.
Did here.
I feel left out. Okay.
No.
Oh, now I see it. Okay.
You got it?
We're good. We're
Okay,
good.
good. All right, so in this first column to the left, what we have is the process that exists today. So an applicant's notified and noticed, and an applicant has 10 days to response. Staff then have to either affirm or disaffirm that. And we have about 35 days from the date that we received notice to make that determination. The applicant then has 20 days once they get that determination from staff to request an administrative hearing panel. The hearing panel has to be scheduled within 90 days, and then we must provide findings and hearings within 30 days of that hearing. The applicant then has 10 days to request a CBE review, and this is 10 days from receipt of the findings and hearings. And then the reviews held at the next regularly scheduled CBE meeting. The CBE then has 10 days to send a determination. So this is the full process can take up to 8 months, and this is considering using all of the full dates. Our intent is not to need 90 days to schedule a hearing. or, to use a full 30 days to provide the findings and hearings. But if we did apply the maximum number of days, it could take up to 8 months. In this second model here, this is what the CBE voted on in December of 2023. So the application would be noticed, the applicant would be noticed. They had 10 days to respond. The staff could affirm or disaffirm the notice within 35 days. The applicant has 20 days to request the admin hearing. Then the CBE would lead the hearing panel at the next regularly scheduled CBE meeting. And then we'd provide the findings and hearings within 10 days. And that whole process, using the maximum number of days, could take up to 4 months. The last column is this new addition of the panel needing, a 3-member panel needing to bring it to the committee. And so here, the item is, the applicant's notified, we have 10 days to respond. Staff affirm or disaffirm the notice in 35 days. The applicant has 20 days to request the hearing. The 3-member panel would meet, and they can meet outside of the CBE meeting cycle, but then they would provide the findings and hearings, a recommendation of findings and hearings to the committee. Here, the committee then at the next regularly scheduled meeting. And then at that point, the CBE can approve, deny, or modify that recommendation, and then issue findings and hearings within 10 days. And this process adds another month at least. And this is contingent also on the fact that there would be a meeting soon to follow. We do have months in a year where we don't have meetings. Like, for example, we don't have meetings in July or February when we have bar exams. So this delay could actually be anywhere between 5 and 6 months. And so, in considering this proposed recommendation, I think that's one of the things that needs to factor in here is the additional time that a CBE and a 3-member panel would add to the timetable. And also that, the idea of eliminating the staff administrative hearing was to incorporate the committee and bring the committee, connect the applicant to the committee in a more expedited fashion. So in essence, so if you look at the last slide, what we are recommending, the staff recommendation, is just basically right now only about the matrix, that the committee approved the proposed changes to the matrix. But in terms of the rule about this change in the administrative panel, we want to open it up to discussion and gather ideas, because I plan to bring a proposal to the next January meeting that would incorporate the consensus, if we have some consensus here today.
So you just want approval of the matrix, not the guidelines, is that right?
Correct.
No, you want the matrix and the guidelines and not the rules, or?
Yeah, and not the rules, because the rules right now conform to, we would be able to basically effectuate the exam rules with study participants. Right now, so the second part in terms of the rules, that is for the next rules draft that's coming in January. So I'm seeking feedback.
Okay, I have a bunch of proposed edits. I apologize. I will self-identify as the mystery committee member that she's been consulting with this year. I could let the matrix go as it is, if we came back to it real soon, just to clean up things. The guidelines, and I suppose the guidelines, I think they do need some work to be clear, and there might be an internal inconsistency or two. And in the interest of time, I don't know if we want to really dig deep in that, because I could talk it out with staff between now and January when we're talking about bringing rules back.
In the interest of time, that makes sense to me. Mr.
Sorry?
Kramer, if you get, yeah, in the interest of time, that makes sense to me. If you're willing to speak with the staff about those changes, that'd be great.
Okay, but on the question of how we want the process to go, I'm also helping them write revise the rule to implement it. And personally, I don't really have a strong opinion either way. If the committee today could give us some clear marching orders, then we could come back with what you want, probably in a fashion that's adoptable. If nothing else, my kibitzing would probably be done, and that would help speed things along. But we do need to know, I think the middle choice here, I see that as unworkable because it's having the full CBE conduct the administrative hearing. Because remember, that's where the applicant comes in and makes their case, provides evidence, an oral statement. Their attorney attends as an advisor, but not as an advocate. And so if we had any number of those, that could easily take up a morning of one of our meetings. And I don't think we don't do it for any other type of hearing of this sort where we have all the members of the CBE involved in conducting the hearing. We have a sub-panel, 2 or 3 members that, whether it's reviewing the informal conference for moral character determinations, the recording of it, and then they make a recommendation to us. So I think it has to be the same way, which would be the third column. Now, another option is to just have the hearing panel make the final decision for the committee. But if we do that, if anybody finds that comfortable, then I think we need to build in some kind of feature like we did for testing accommodations when we thought we wouldn't be hearing them anymore, which is to periodically review all of the decisions and make sure we appear to be being consistent. Because that's certainly our oversight role. When we're making the decisions ourselves, I think the oversight just happens by virtue of our doing the work. But if the full committee's no longer doing it, and these panels will be different people every time, we would need to have some kind of audit option. So if the committee can say, tell us how we want to do it, I can help staff write the process. We're kind of there, but we're kind of stuck because we don't know exactly which way to go.
Excuse
Ashley's
me?
had her
Yeah,
hand up.
right.
I just wanted to advise, I had to rejoin. My internet in my office is down, so I will not have capacity for camera until that's back up.
Thank you, Ms. Wisman.
Judge Reyna has the hand up.
Yeah, I'm just curious, I can't recall, but what's the time commitment? How many hearings would there be if we were to do a 3 member panel that would have to do it in between meetings to advise the third column option? Do we know approximately how many we get exam?
The numbers have fluctuated. So we had this past cycle, at least from the July bar exam, I believe about 8 to 9 hearings. And I think based on the exam modality, some of these will no longer exist. Like, for example, some of these were people cheating from based on looking at somebody's paper to looking at a neighbor's paper, and that is in a remote or a hybrid exam. The chances of that happening are much lower than they were for a full in-person exam. So I think that 8 to 9 is probably going to be. I don't think we'll achieve that in these hybrid exams that are upcoming. So, but I can't guarantee it as well. So I'd say, maybe anywhere between like, I don't know, 3 and 5 as violations, I imagine, because we're not bringing all violations. They are the ones that are disputable. And so the disputable violations are the sole ones that are going to be coming to the committee. Yeah, I don't know if that answers your question.
And then just so that I understand, then the 3-panel committee would conduct the hearing. So as Mr. Kramer was
Yes.
saying, take evidence, approximately how long does each hearing take?
They've been scheduled for an hour and some, and most have taken less than that. It's on rare occasion that we've gone the full hour.
So possibly, and then it seems like hopefully it would be less violations with the new modality, but we might not even be envisioning new type of violations as a result. Hopefully there won't be, but anyways, okay, so then there'd be maybe up to 5 hours for this 3-panel committee in between meetings that we might have to take, right?
Well, and the other thing that we can do too is a possibility is have multiple 3-panel members so that you know, this task could be assigned to more than just the same 3 members.
You'll probably never get them all, be able to schedule them all on the same day, even if you wanted to, right?
Yes, that's true. They're all on a different time cycle.
Couple of things. This is the three-member panel is reminiscent of when we used to do the moral character determinations outside the presence of the committee. And I think it's a far more efficient way to do it this way. As Paul points out, 2 or 3 of these for the entire committee to listen to will easily take up the bulk of our time at our general meetings. And the fact that you would have so many people sitting in as fact finders will simply multiply that time and make it even more difficult for the applicant. So I do favor the three-member panel hearing outside the presence of the committee. Question. The second step or third step in the process, staff can affirm or disaffirm the notice. You're saying that sometimes staff can simply look at this and dismiss it right at that point? Is that what that
Yeah,
means?
So for example, in that first step, we send the notice to the applicant explaining the violation, the circumstances. An applicant has 10 days to respond. So we wait for that response and they might share information that explains their behavior or explains the situation. And at that point is when we make that determination whether to affirm or disaffirm.
Oh, I'm asking what that term means. You're saying.
Oh, what disaffirm means? It's to nullify the initial notice.
All right, dismiss the charge at that point. Okay.
Yes. Mhm.
Yeah, that's a better word, dismiss.
Yeah.
Yeah, okay, I'll make a note.
So what's the basis for suggesting a 3-member panel as opposed to, say, a 2-member panel?
None. I mean, you might have a tie, you know, if one member's a yay, another's a nay, in terms of upholding the staff determination. A third person could help with a tie. Yeah, I think that's the thought process.
Makes sense. I think my only concern is, given the composition of the CBE and given the number of hearings, I wonder if we have enough time in a day or the bandwidth to attend to all the hearings. And so the way to alleviate that is by, having a smaller panel, obviously without sacrificing performance and efficiency, but also, making sure that we have enough people to attend to all of those hearings. Now, in the case of a tie, I would assume that, that would be brought to the CB's attention, after which we would then, discuss, debate, and vote on a specific applicant. But I'm just thinking, what, if anything, could be done, given that it sounds like there is a significant time commitment in attending the hearing and also, reviewing materials. Again, it's just food for thought. I don't have anything concrete, but I just wanted to make sure that we have thought through the time commitment and the bandwidth related issues.
Yeah, it makes sense that the full committee could be the tiebreaker.
Yeah.
Yeah.
Because right now we have 15, 16 members. And so, obviously that's not the business. How many do we have right now? What's the latest head count, Audrey? Do you have the, I'm going to have to look at the roster right now just to confirm.
14. Is that right, Devin?
So,
Yeah.
Yes, 14.
And I understand Supreme Court is perhaps considering additional candidates. But in the meantime, we don't have 15 members, so the number's not divisible. So it sounds like maybe for now, a two-member panel makes a little more sense than three-member panel. Again, I'm just throwing ideas out there just so that we can all think about, how best to proceed.
Does that mean we need a rule that if the full committee ties, that the applicant wins, just to avoid that problem?
Yeah. I mean, honestly, this is no different than what the traditional approach that we used to have, right? For moral character, for example, where there are issues, we would bring forth the issues, the committee would discuss it, either ratify it or change it. I would assume the same approach would be adopted here.
Well, the moral character, the burden is on the applicant to show that they are of good moral character. Here,
Right.
who has the burden of proof here? I would think it's the committee to prove the violation.
It is a committee.
So if
Right.
there's a I amongst the entire committee, I guess it would fall to the applicant because we failed to discharge our burden. Correct?
Yeah, maybe we should be explicit about that. but
Yeah.
We'll think about it in our group.
Okay.
And I think, is it Vince who has a hand up?
Yes, I have a question. If it's a 2 or 3 member panel, would one of those members have to be an attorney member? Similar to what we do with the moral character hearings? Would that be necessary?
I think it'd be helpful. I don't know about necessary, but it is something that if this group finds it necessary, we could make that add that specificity to the rules.
Yeah, I didn't have an opinion one way or the other. It was more because we're spreading responsibilities out to a number of people.
Mhm.
And that may, if you have to have an attorney, it may lessen the amount of people who would be available.
Where does the moral character rule come from?
That the burden is on,
No, that one of the panelists has to be an attorney member.
I don't know that is a rule.
Yeah.
I think it is.
All members are competent to decide on their own what's best, and whether anything's appropriate. So I don't really see why we would limit it to a specific group of members.
Tara, sorry. Tara, when the informal conferences were held by the committee, was there a requirement for the panelists to include an attorney?
I believe so, but the current procedures for the informal conferences, which the committee approved, have that caveat still. So one member does have to be an attorney or a judge, as Vince mentioned.
So then the question is, what was the rationale for that, and does it apply equally to these?
I think the rationale was likely because legal issues can be raised during an informal conference, like the unauthorized practice of law.
Here, we don't really have same rationale, meaning we don't have any legal issues that we need to consider, right? Amy, are you able to come up with anything where legal knowledge may be relevant?
No, I think that the establishing the burden of proof, and then also the level of evidence, because our evidence, the standard is clear and convincing, and so sometimes that comes into play during some of these sessions, and so I don't know if that warrants the need for an attorney or not.
Very convincing. But juries of lay people have to make those decisions every day in civil cases.
Yeah. And currently no lawyers are on these panels, so they're being handled by non-attorney staff.
Yeah.
Doesn't sound like, I'm not hearing that it's absolutely necessary.
Nor could I think of any reason as to why that would be. So unless anyone has additional input,
Yeah.
I would
Judge
say,
Reed.
Judge Reyna has her hand.
I'm sorry, Judge Rainey.
No,
You're
sorry,
recognized.
I was just gonna advocate that it could be non-attorneys. I think that's what we're falling on anyways. And also I would advocate a two panel committee just because of the time commitment, it seems to me, and the amount of turnaround that we have and all the other subcommittees that we join in. I think for time, it would be better to have two. That's just my thought.
Okay, so just to be clear then, what I'm hearing is that a two-member panel that can be comprised of attorneys or non-attorneys, that specificity is not important. It would be sufficient. And I guess my question is on the back end. So those two-member panels would bring a recommendation to the committee, or would their recommendation hold as the committee's decision unless there was a tie? Is that the consensus?
Well, I think the standard approach would be for all decisions to be brought forward to the full committee to either ratify or to change. I would assume, we should, or we could still use the same approach, meaning, well, I think Mr. Kramer may have some thoughts on this as to what is best. But my understanding has always been, you have different members or different groups of panels making their own decisions, and then they would then recommend what they vote on to the full committee to affirm.
That would be more interesting, I think, to most members of the committee than trying to do the audit I talked about, which would just be reading tons of files and trying to ask yourself, are we being consistent over time? I can go either way. I just, in this case, I don't have a strong opinion.
Obviously some form of deference would have to be given to the panel who makes the initial assessment or determination. So I can't think of instances where the full committee would go against that assessment unless, something peculiar comes up where we discover that's really, maybe something that you haven't considered. I don't know, but Mr. Kramer, is this something that you're willing to consider and give us your thought either at the next meeting, or is this something that we have to vote on today?
Well, ideally, I'm your Scribner on this one. I just want to know what you want to do, and then we'll bring it back in January, hopefully ready for approval.
And is this something you're willing to do, meaning take back all the feedback and comments and then to revise as necessary and then get it ready for a full vote in the January meeting?
Well, if we could make up our mind today, then the work would be easier because we just have to write one version of, several sections probably of the
I'm a
rule.
proponent of the two-member panel, and sounds like Judge Reyna is the same. Anyone want to propose or support the three-member panel idea?
Well,
So feel free to raise-
Vince's hand is raised.
Oh, I'm sorry. Just Mr. Reyes. The floor is yours. You muted. There
Sorry.
we go.
No, I'm fine. I just want to agree with the two-member panel.
Okay, and then the second part is, do they make the final decision unless they tie? Or do they just make a recommendation to the full committee?
I would support making the recommendation to the full committee.
Okay.
I think there should always be that oversight. There's also the issue of consistency. If there happens to be more than one panel at a particular time, there might be different approaches. So as long as it's clear that the full committee is not going to hear it de novo, we're not going
Right.
to hear evidence
And we don't have to usher in the applicant to
Right.
speak to us again.
Right.
Yeah,
It
that's,
also affords consistency and credibility too when the full CBE gets to, talk about it, discuss it.
Right.
okay. So I have marching orders on the rules. Now today, Amy would like us to approve the revised guidelines. And the matrix. And none of the changes I have, I think, need to stop the immediate approval, so long as I get my shot at it when we come back with the rules to perhaps revise both of these somewhat to clarify things. But I don't want to take up your time today. Adopting this temporarily today lets them do the work they need to do with the experimental exam, and then we can bring everything back as a package in January, and with my seal of rightness, and then perhaps send it on its way.
Works for me.
So
we
I
have a proposed
motion.
motion.
Oh, yeah.
Yeah, go ahead, Amy. I was going to say, go ahead, Amy.
I was taking your lines. Go ahead, Alex.
Well, we have a proposed motion in front of us, and so given that these changes will not impact the motion, unless there are any additional comments or questions, I need someone to make the motion.
I'll make the motion.
And I'll second it, Alan.
Mr. Kramer making the motion with Mr. Yokelson second. Any additional discussion or debates? Hearing none, Devin, please take the roll.
Dr. Bolton,
Yes.
Dr. Cow,
Yes.
Kareem Gangora, Larry Kaplan,
Yes.
Paul Kramer,
Yes.
Alex Lawrence,
Yes.
Esther Lynn, Justice Masiwala,
Yes.
Bethany Peak, Ashley Silva Guzman,
Yes.
Judge Reyna,
Yes.
Vince Reyes,
Yes.
Alan Yokelson,
Yes.
Alex Chan.
Yes.
With 11 yeses and 0 nos, the motion passes.
Thank you, Devin. On to item 4.2, which is discussion on unaccredited law school rules review and proposed rule revisions. I understand we have a report from Cody and Natalie. Please take it away.
Great. Thank you so much, Chair. And Natalie, if you could share the slide deck, that'd be super helpful. Thank you. Okay. Well, while that's loading up, let me just tee up the purpose of today's discussion. Oh, perfect. We can see it, Natalie. Thank you so much. So the purpose of today's discussion is threefold. One, we want to present to the committee the second draft of the proposed rule revisions. Two, we want to share feedback from law schools, CS bars, and other stakeholders. And then three, and I think this is the most important part of today's discussion, we want to share with you some areas where we believe that additional committee feedback is needed to make final determinations. So my hope for this discussion is to kind of walk through each consideration, provide feedback that we've received, provide some data, and then tee up a discussion before we move on to the next area that needs discussion. So I think we'll tackle each issue one by one. Before we move forward, I want to just refer members to Attachment A and Attachment B that were part of the agenda item. And I just want to point out that Attachment A includes revisions from the first draft, which are identified using single underlines and single strike-throughs, and revisions made in the second draft use double underlines and double strike-throughs for those that are looking at the materials themselves. Okay, so let's move forward, and we can actually skip this next slide. That's just reiterating the purpose. So before we get into the new content, I just want to summarize what was accomplished or what was discussed at the August meeting. So in August, we introduced a range of proposals, some focused on technical revisions. We integrated some policies from the guidelines and brought them over to the rules, and we mirrored some of the effective accredited law school rules where it was deemed appropriate for the unaccredited law schools. Where there was more substantial revisions were areas such as the disclosure policies, where clarity and some enhancements were included. We introduced a new student complaint student complaint policy and record-keeping requirement. And we provided some additional language to clarify the major change requirements, which comes up often in the committee's work. And then lastly, this will be some of the topics discussed today, there were entirely new rules introduced in that first draft. We modernized the law school categories, and we will talk about that. We introduced a 5-year cumulative minimum bar pass rate, similar to that for the accredited rules, and that will also be discussed. And we also expanded acquiescence procedures in a way that would better capture the impact of non-JD degree and non-degree programs at law schools, such as certificates and credentialing programs. So that was what was proposed in August. Since then, if we can go to the next slide, we've had pretty substantial feedback, and I'm going to ask that Devin promote, I see there, Dean Frickberg. Before Dean Frickberg provides some summary, I just want to set the stage here. So staff has been connecting with our law school stakeholders and particularly CS bars throughout this process. As a reminder, in March 2024, we met with both CS bars and the Council on Access and Fairness, and that aided us in developing some of the initial proposals for options to enhance outcomes, which were incorporated into the rules. Since then, CS bars met twice, once on October 8th and again on November 1st to provide feedback on that first draft proposal. And so we've asked Dean J. Frickberg, who is the Dean of University of West Los Angeles and also the chair of CS bars, to come and summarize that feedback that was discussed at the those two CS bars meetings. So Dean Frickberg, I'll pass it to you.
Good afternoon, everyone. And first, I'd like to start by saying thank you to staff members Nanian and Leonard. I think if you review attachment 4.2, it does a great job of coalescing the conversations and dialogues that have occurred. I'll just try and hit some of the high points, and I'm always here if there's any questions that I can help facilitate the discussion. I think the first area focused more on a conversation on the modality. I think that's a great change. I think some kind of archaic language was used historically, fixed facility, distance education, correspondence. And I think in the modern parlance of students, from their perspective, they want to know, is it synchronous or asynchronous? Is it live or is it not live? So I think that's a great change to bring us to the modern times. There was a conversation concerning the major change component and whether or not that should be inclusive of a move of a campus location less than 5 miles. Currently in the accredited rules or the WASP rules as well, that would not be required. But staff mentioned that there's probably a better justification for that in the unaccredited registered schools section. But that was one area of conversation. There's also a conversation on should there be specific time periods for the committee to get back to a school. There's always a specific time frame for the school to get to the committee, but should that be reciprocal? And that might vary and be different to do because of the equity interests of every school being different, especially in the registered unaccredited space. The other major areas I would broadly group together under what I would consider disclosures and transparency. One being there was a conversation, should there be continued use of the phrase unaccredited? There was a disagreement within the CS bars on that. Some schools argued that having the phrase unaccredited made it difficult to attract students to that sphere. Others, full members of the CS bars, were concerned that if it took away unaccredited, would that be misinformation to the public itself, to the potential students? So there was a conflict on that. Another area was the requirement now of having proof that a student for a registered unaccredited school has registered with the state bar as a law student. Primarily the concern on that is just the evidence of it. Currently there's no mechanism for the state bar to give to a school to evidence whether or not their student has registered with a 90-day mandatory requirement. So I think it's not so much a pushback on the idea, but what is the best evidence of that proof of registration? Then we had a concern that was brought up on student complaints. Student complaints being not really defined well. So if a school is required to maintain student complaints, would that be of a formal or informal nature? You know, if a student is concerned that a classroom is too cold, would they be required to document and mandate that within their record keeping? So that in the CS bars conversation, there was a dialogue on whether or not there should be a further refinement of what is a student complaint for student complaint requirement purposes. Much larger conversation on NPR, as we already have it for the accredited schools, and now having as a parallel for the registered unaccredited. Similarly, there's a conversation, should there be now a first-year law student NPR, and how that might be a better indicator for a registered unaccredited school. However, the pushback on that was the first-year law students exam went through a radical change this past June, or not only being online, but also 100% multiple choice. So we're not sure what is a good baseline for that was within the dialogue itself. One that I thought would be very helpful, and I think that we had a very good, robust conversation on, was the idea of attrition, reporting attrition numbers. So should there be some type of public indicator of what is the attrition of a school within their first year, where most academic attrition occurs in law school? I think from our conversation, there's a discourse, should there be a bright line like our NPR? And they moved back and forth, 50, 70% attrition, you know, what would raise an eyebrow, as it were. I think that would be an area that should have further conversation. But I think in the interest of public disclosure, I think that would be very useful. You know, if you were a student, would you want to know how many of those students that start that program make it into their second year, as well as complete and ultimately pass the bar? The last area that we were focused on was standardized testing, which, similar to the LSAT, many of us that are lawyers have already gone through. Now, although the staff report references Bolus's report from 2018, that's one area I think there could be disagreement on, because Bolus's report, Dr. Bolus from 2018, focused on ABA schools in California to find that correlation between LSAT score and ultimate bar passage. And if we go to LSAC as another indicator, LSAC argues the LSAT itself is only a good indicator for first-year performance. But again, as long as everyone has applied the same rule and that rule is public and transparent, I think that is definitely a good idea. And I think that was the resolution concept from our CS bars meeting. Those were the major high points from the conversation.
Thank you, Dean Fixberg. So back to you, Natalie and Cody.
Thank you, Chair. Well, I think that's good news because Dean Frickberg mentioned a lot of the information that I'm actually about to summarize. So I think we heard the same thing in that meeting. I just want to take a moment to thank Dean Frickberg. He's been a great partner as the chair of CS Bars, and also the entire membership of CS Bars. The discussions over 2 days, I think, were quite robust, and members kind of took ownership of leading specific areas of discussion. So that was really helpful. So let's put the slide deck back on. And I want to actually quickly summarize some of the feedback that's already been incorporated. So I would just remind the committee members that Table 1 in the staff report includes a more detailed summary, including areas where no action was taken. But let's go to the next slide, and I'll just quickly summarize where feedback was incorporated in Draft 2. So as Dean Frickberg mentioned, there was a discussion around these new definitions for the law school categories. There were some references in the definitions area of the rules in the first draft that some felt were confusing. We did remove those. And we're going to talk about this further, but Rule 4.240B3 adds a certain another layer of detail regarding what we mean by principal method of instruction. So we've clarified that law schools are allowed 20% of courses and 20% of each student's instruction per term to use alternative methods. And I'll just point out that in that meeting with CS Bars, there was a suggestion from at least one member to add a hybrid category. And we believe that at this time that's not necessary, and the 20% threshold, provides appropriate flexibility. And then Dean Frickberg also mentioned disclosure requirements. There was feedback that some of the disclosure requirements could use clarification. We added some disclosures, we added Rule 4.241BD, B through D, which ensures and clarifies when disclosure actions should take and ensures that those actions are taken before any financial or enrollment commitments are made. And then there's just various other clarifications to that area regarding the timing and content of disclosures. And then major changes were also mentioned. There was feedback, again, that clarification of the rules, clarification of the language of the rule would be helpful. So Rule 4.245A defines major changes as a significant modification in a JD program. We've used language that we've aligned with the ABA's language and provided some additional clarity regarding what we mean and what constitutes a new division of a JD program. And for brevity, there's other clarifying language in that section that I'll skip over. And lastly, related to the non-compliance process, stakeholders did request a provision to allow early termination or extension of a probation period. So rules 4.264 F and G now allow schools to request early termination or extension of a probation upon demonstration that compliance has been achieved or a clear plan to improve compliance. And Dean Frickberg did mention the student complaint policies. There was concern, as he mentioned, that the scope of the student complaint policy wasn't well defined and perhaps that the record-keeping requirement could be burdensome. What we've added is Rule 4.205 language that clarifies that a complaint record should be retained for 20 years. What was determined is that that would allow the State Bar staff to identify long-term trends across multiple inspection cycles. Okay, so now let's turn to the next slide, and this is really the heart of today's discussion. Let's see here. So as I mentioned, I want to introduce some areas where feedback is required at this time, and I will pause at the end of each section and open it to the committee. We want to start first with assessing these new law school categories and this idea of a principal method of instruction. As we've already mentioned, the proposed rule replaces what we call right now fixed facility, distance learning, and correspondence categories with synchronous and asynchronous instruction. We believe this achieves the goal of aligning classifications with modern practices. And as you heard from the dean, there was general positive feedback from CS bars over those 2-day worth of meetings. There was some concerns raised about the effectiveness of the way that we are describing asynchronous and synchronous instruction. And there was also a request that we better define what we mean by principal method of instruction. And so I want to go to the next slide. And what we want to hear from the committee today is, are these descriptions sufficient? Is the 80% requirement appropriate? And of course, we welcome any additional feedback. And I know this section is particularly dense, so let's go one more slide over and we'll show the language for principal instruction. So we're describing asynchronous instruction as instruction that allows students to learn at their own pace and on their own schedule without requiring students to be present at the same time, whether in person or online, as their instructor and classmates. We believe that that describes pretty clearly the kind of instruction that a student would receive currently really under some distance learning schools and correspondence law schools. And then moving forward, we have synchronous instruction, which requires instructors and students to gather at the same time, whether in person or online, for an interactive, real-time classroom experience. So I'll leave this section there and just open it to the committee if they find that these descriptions are clear, or any additional feedback. Any feedback on those descriptions? Okay. Well, then the next component of that. Yes.
Cody, so how do we define principal method again? I don't see it. And obviously, I understand asynchronous. It sounds like asynchronous means self-learning, self-study, whereas synchronous means you're studying and doing things synchronously or at the same time. help me understand how principal method applies in these instances.
Yeah, let's go to the next slide then. So we added language to try to better define the term principal instruction. Some of the considerations that went into this language were whether or not principal method of instruction applied to a program as a whole or individual student's experience. And we believe that the requirement should really apply to both. So a school should operate under at kind of the macro level under a principal instruction method, but each student should also have a experience at the law school that reflects that principal method. So that way you don't have a school operating principally as a synchronous learning school, and yet there's a student who goes through the program and never has a synchronous course.
And the reason for the distinction is because the statute has different hours requirements to make up a year of study, right?
What do you mean?
Well, the statute says for in place for it describes fixed facility schools, says you have to have the
Correct.
270 hours, which is really three times 270 because you have to add in the study outside of class. Whereas for correspondence schools, they have the 864, I think it was, hours requirement. So we have to live within the statute. Ideally, we could have perhaps a more well thought out requirement for study, maybe not even distinguish between the two, but we're stuck with the statute at this point.
Correct. So the two categories themselves, I think, fit well in that kind of two scenario situation that the statute describes, the 2 hours. Right now, I think the existing system essentially takes what the statute describes as two different scenarios and creates three categories out of it, which is somewhat clunky. This new option does a good job of conforming to the statute more directly. And then regarding the principal method, I think, Paul, what you're suggesting is if a school operates as a synchronous synchronous instruction method, they have certain hour requirements, and so a student's personal experience would also need to comply.
Yeah, we'd have to somehow figure out what the statute intended if it were a hybrid, half and half, and that would be interesting.
Exactly. And that explains the 20% flexibility, but no further additional hybrid option.
I think that's also my question. For a hybrid school, how do you decide which one is the principal, which one is the alternative method?
Yeah, that would be a problem, and that's why that's not, there is no hybrid category under this proposal.
And so I guess they really can't be hybrid in that way because we would not recognize the study to allow one to take the bar.
But what about for a school that operates completely offline? In that sense, would the principal method be what, online teaching?
So under this new proposal, that would be an asynchronous school.
Cool. Okay.
So
unless you mean via Zoom, which is synchronous.
Right.
Yeah, the way that these rules would contemplate a distance learning situation would be the term real time and the self-paced component. So if you're an online school, but your instruction is provided via like recording or some other offering where a student can access it on demand or at their own pace, that would be asynchronous. And then synchronous instruction could be online, but it would be a scenario in which students must be present at the same time in the online environment.
Thank you, Cody. I don't have any more comments. Any comment from any member of the committee?
Okay.
Cody, yes, we can talk about the next one.
Yeah, let's move to the next category here. We've introduced in the unaccredited rules an NPR requirement. As it stands right now in the proposal, that requirement is 40% as it is for the accredited law schools. And I just want to share some of the considerations that we feel are important for the committee to be aware of. I think there is some rationale for why there might be a uniform NPR across both categories. That would establish a consistent performance baseline. And we do know that as of right now, all but 2 unaccredited law schools would meet the 40% threshold. But we did receive meaningful feedback in those discussions with CS bars and other law schools, and I want to share their thoughts. So there was one kind of area of feedback where I think the unaccredited law schools would say that they have unique student bodies that are more diverse, older, perhaps less advantaged populations. And the nature of the schools themselves, they're often operating under fewer resources. And I think their argument would be that a lower NPR kind of would reflect the differences between these two categories, both from a student population standpoint as well as a resource standpoint. It would also offer kind of a pathway and an opportunity for improvement towards accreditation for schools that they're currently operating in the unaccredited category. There was also, I think, an important concern about the impact of a uniform NPR when it comes to schools who were once accredited and lose their accreditation because they no longer meet the NPR requirement. So as it stands right now, an accredited school can lose its accreditation due to NPR noncompliance, and they can apply to operate as a registered unaccredited law school, which gives them an opportunity to improve their pass rates and continue to serve their students. Let's go to the next slide here. One of the reasons that we've introduced the NPR requirement, without considering the percentage, is that we think it's pretty well demonstrated as an effective tool. So this data just shows the average NPR by year in the accredited law school status, and we can see since its introduction, or at least since we've got data since 2018, we've seen an increase in the average NPR in that category. So what we want to hear from the committee on this point really is pretty straightforward. Should that NPR percentage, the minimum requirement, differ for the unaccredited law school category, meaning perhaps a lower percentage than 40%?
So Cody, help me understand. So by my count, there are a total of 11 unaccredited law schools. Am I right? As of today?
I believe that's right.
So all but 2 of those law schools have not met the 40% NPR. Is my understanding correct?
Correct. So we've been asking unaccredited law schools to report their NPR data on the recent disclosure forms. I think we have all but 2 are confirmed as above the 40%. We have 1 school that has reported a number below the 40%, and I think there's 1 school that just has not reported a figure yet. But we do.
It sounds like, right. So it sounds like the majority of unaccredited law schools, at least the majority, as what I'm hearing from you, is that they are able to meet the NPR. So what's the justification in the context of potentially lowering that NPR when most of the schools are doing just fine with the current rates? Do we have a rationale to lower it? It sounds like that's really the crux of the question.
Well, I think one consideration for the committee would be whether they believe the unaccredited law school category should be, how do I put this? Should be a space where schools who were once accredited can try to improve their performance. So that scenario in which a school is accredited, loses its accreditation because it's not meeting the 40% NPR minimum, should the unaccredited category act as a space for the school to improve their outcomes? That's one scenario.
But the committee can always exercise discretion to put them in probation, meaning they don't have to lose accreditation right away. And oftentimes we do give them some flexibility to provide us evidence of an improvement. Right. Well, I mean, we have done that in the past, and my understanding is we're still doing it as of today. And so I think losing accreditation or the fear of losing it overnight is not something that is realistic. So with that said, I'm happy to hear from other members as far as, whether this is something we need to consider. I know personally for the past year or two, there has been some concern about education performance or teaching standard and making sure that all the schools uphold their educational standards, so that they don't lose sight on focusing on the students and giving them a reliable, a trustworthy education. But again, I don't have a fixed mindset as far as which way to lean on. So I would defer to the committee as far as whether this is something we need to think about.
Alex, one thought with regard to that is that probation in the accredited rules, and soon to be if their themes are moved over in the unaccredited rules, is generally limited to 2 years. And if improvements to the NPR often take longer than that, because you're, if it's necessary for you to improve your educational program, the first year students won't even be able to take the bar for 4 years. So if in order to make your program compliant, you have to start basically at the beginning in the first year class, 2 years likely won't be enough to show the improvement you need to get back over 40. I mean, maybe we could design some kind of special probation for cases where if that's your only problem, you can have some extra time. But I think that's a complication to treating probation as a solution for this kind of longer term deficit.
And I can see how this could potentially open up a can of worms. For example, if they are in fact improving, would that mean we should come up with a rule so that we can see actual improvement? For example, maybe we can give them a 3-year probational period where every year they have to improve by X%, right? We're going to have to see improvement to give us that sense of confidence that the schools are in fact contributing resources to enhancing their educational programs and doing things in relation to NPR instead of just setting on the wayside and then just, call it a day. So I think really at the end of the day, what can we do to help these unaccredited schools meet the threshold? But right now, it sounds like the majority of the schools are in fact meeting it. So, would it be something that we ought to think about, meaning we need to carve out some exceptions for these schools? I don't know. I don't have a real answer to that.
Okay, so maybe what I'm hearing is there's an opportunity to think creatively to maintain this uniform minimum requirement, but ensure there's some considerations within the rules for these scenarios that we're describing.
And it sounds like putting the requirement in is not in dispute. It's just what the number should be. So
exactly.
That we have to send the rules out for comment once we get them to the form we like, and so there's all that time to consider more feedback and think about what we ultimately want to do.
I mean, it is also within our best interest to provide some milestones, something to incentivize these schools who are not meeting the NPR to do what they need to do to meet the NPR, right? We don't want them just to lose accreditation and then just close the school altogether. And so some thought must be given to what we can do to provide those additional guidance for the schools to be motivated and to be incentivized to meet those milestones.
Yeah, I mean, in the past, you've talked about us finding ways to help schools improve themselves, and I've always found it to be a difficult challenge because, some schools don't want our help. They want to be left alone, and of course, that's not our approach. There's only so much we can do. We perhaps in some ways are as deficient in resources as they are when they're in that situation, given our budgetary limitations and staff resources.
Yeah, but lowering their NPR isn't going to do much for them other than maybe kicking the can down the road just so that it can survive for a few more years. But if they're not meeting it, I don't see how they would meet it at the end.
Yeah, it's a tough one.
Okay, any additional comments, input from anyone else?
Was there another question, Cody?
Not there. I want to be mindful of time, so maybe we can just briefly touch on this next one before we get into, I think, a topic that requires some more discussion. This is, I think, very much related to what we're already talking about, but through our work, as I mentioned, the NPR appears to be kind of a pretty effective tool in the sense that we have demonstrated success. We've seen that it has improved outcomes. So I think that had staff thinking about how do we establish some additional clear kind of metric-based solutions. And so an idea that was discussed at the CS BARS meeting was introducing a minimum pass rate for the first year exam because the first year law students exam applies, kind of uniquely to this category of law school. And let's put the slides back up one more time. I'll briefly just share some data that I think will inform this component. Perfect. Let's go to the next slide. Let's skip right over that and we'll just share the data. Oh.
But if for some reason my arrow keys aren't working, so I'm going to try to just bring it up off of the here we go. Off of the screenshot. Okay. Here we go. This way we can move ahead.
Okay, thank you so much, Natalie. Let's just skip over this and I can briefly talk about what considerations we want to share. So the idea is that a similar pass rate minimum could be established for the first year exam. But as Dean Frickberg mentioned, CS BARS raised two, I think, reasonable considerations. One was the fact that pass rates are highly variable in this category, particularly because they have small student bodies. And so we're sharing, and it's a little bit hard to see because we don't have the full window here, but that's okay, I can describe it. What we're seeing is the pass rates in June 2023 and June and October exams from 2012 to 2023. And you can see that the pass rate for the different categories of law schools is highly variable. What we've added on top of that is a red line that shows you the June 2024 pass rate, which was 32%. And so, as Dean Frickberg mentioned, CS BARS members felt that perhaps maybe this is not the right time for a first-year pass rate minimum, and that further data and research essentially is needed to further analyze the results of the recent first-year exam changes. So the question for the committee is whether or not a first-year pass rate minimum for this category is appropriate at this time. I think one consideration is perhaps it's unnecessary considering that the requirement that students pass within 3 administrations of the exam may already kind of effectively provide a consumer protection piece. But we wanted to bring it here because this has been an idea that has been discussed and that CS BARS members had an opportunity to explore, and we wanted to gather feedback from the committee today.
Three examinations is a year and a half, though. So they could spend another year and a half's worth of tuition before they find out that it's not going to work. Mm-hmm. So for those who are concerned that we protect students from wasting a lot of their money on an education that's not going to bear fruit for them, that might still be an issue. As I've said so many times, I can flip either way, or is it more important to let people dream, or as long as they know what the risk is, or to protect them from wasting their money? It's a coin flip for me some days. They're countervailing policies.
But let's say we have this NPR. What would be the administrative impact if a law school does not meet that NPR? Or is this more of like an informative parameter that law students can use to gauge where they are in terms of their success?
I mean, as it stands now, the thinking would be that this was a required minimum, just like the NPR is. As I mentioned already several times, we believe the NPR works because it is a clear metric-based requirement. It's one of the more black and white requirements that we have within the rules. And so it's a strong motivator for performance. So as we have thought about it so far, that has been the thinking for this. Alternatives could be to or just report the data, can be added to disclosure, or the state bar can add it to its own published data. That could provide at least a consumer information component.
With the class so small, are we prevented from providing that data on a lot of schools?
Well, we do not publish individual pass statistics for a single year if the population is very small. Over a 5-year cumulative, if that were the design of this, I'm not sure any schools would. The number might be enough to report on that. I have to look into that. Yeah.
So does that mean if a law school does not meet that first year NPR, then they would potentially lose their accreditation? Is that the thought process right now?
The registration, yeah.
If it were to very closely mirror the NPR, then yeah, that would be the case. We have not proposed language for this because I think we wanted to hear from the committee whether it's worth exploring in the first place, and particularly with these considerations and feedback from CS bars.
I can see the downside of having it actually, because they could potentially give the false impression that this would be indicative of their success when they take the bar exam. I could see how an applicant would look at the law school's first year law NPR to determine whether they would be successful, whether the school would provide them with a quality education down the road. Again, I don't have a hard answer one way or another, but I just wanted to make sure we consider, what an applicant would think when they see this NPR.
Yeah, true. It's not about the applicant at all when they're applying. It's about the quality of the education.
Mm-hmm.
The first year education really only, but that's the key.
Any feedback from any other member of the committee? These are tough questions. So thank you, Cody, for
That's why we're here, because these are really the issues that have not fully landed in our discussions and did require some more feedback. I know this is running. Let me just touch on the last few points pretty quickly. The next one was the one that I think is, well, I know, Paul, this one is particularly interesting to you, but whether or not there should be some requirement related to attrition explicitly to support improvement in retention. And that would align with the State Bar's goal of increasing the number of diverse attorneys. We feel that improving retention and lowering attrition at these diverse law schools is one way to do so. I think Dean Frickberg touched on it, but we did discuss at the CS Bar's meeting an option to set an attrition baseline. Again, like another very clear black and white metric. There was no consensus from CS Bar's members about what an appropriate figure could look like. Some floated that 50% or 70% attrition was a red flag. The average in first year attrition in the category is 48% in 2023. And there was some debate over whether or not 1L attrition or 2L attrition is a better reflection of the school's practices. Some argued that high 1L attrition might be more of a reflection of the school's mission to provide an opportunity to students, but that 2L attrition maybe reflects what would be more earnest practices disqualifying students who have demonstrated an inability to succeed in the program. And then there were some other alternative ideas proposed. I'd say that none really took full form, but some ideas that were floated by members were using an attrition figure to trigger a mechanism for the State Bar to provide additional support. I think to Paul's comment just a moment ago, it's not entirely clear what kind of support that would be, or there was really no discussion if it would be effective, but that was floated. Another consideration for the committee to consider is that we do use attrition data in our assessment of a school's compliance. You know, we use it as kind of a holistic approach when we are looking at a school's program of education. So it's not that attrition isn't currently used in our compliance efforts. It's just not explicitly mentioned in the rules in that way. So I want to share this data to inform the committee. This was from our law school performance report, the last one with 2023 data. And you can see 1L attrition at both CALS and unaccredited are somewhat similar. The unaccredited category does have higher first-year attrition and higher academic first-year attrition. The difference grows really in the second year, where attrition at unaccredited law schools is 36%, and at CALS is 18%. And so we've added these red lines here to show that between 1L and 2L, the difference is quite large at CALS, and it's much smaller at an unaccredited school. But I'll point out, you know, a portion of that second-year attrition is related to disqualification for an inability to pass a first-year exam. And there is a large percentage of students at unaccredited law schools that attrite in the second year due to non-academic reasons, although even those can maybe be indicative of poor practices, perhaps not fully informing a student of the requirements or the expectations required to succeed in a program. So with that, we wanted to really kind of open the floor to ideas. I think we want to hear from the committee whether setting a baseline on attrition is desirable to the committee. If not, if there's another requirement that is interesting. As I mentioned, there were these loose ideas of a triggering mechanism for support. Paul, I think you've shared some ideas over time. And I guess we would ask the committee to consider also how any proposed attrition requirement would both provide a reasonable opportunity to go to law school, but also address the reasonable opportunity to graduate and actually seek licensure.
Cody, when we say attrition, this is really related to non-transfer / academic attrition performance, right? Because obviously then there are students transferring, you know, after 1L, and so those statistics wouldn't be relevant for the purpose of our consideration here.
Well, I think one area where this third point is further data collection needed. We could expand our own data collection efforts to paint a clear picture of attrition beyond 1L and beyond 2L. Our detailed attrition data that we just showed you from the law school performance report really only goes back at that level of detail 2 years. So one step that could be taken before a new requirement is introduced is just to gather some more information so we can bring a clear picture to the committee.
Do you know if ABA collects that data from all the ABA accredited schools?
Well, they certainly collect some attrition data. We included in our law school profile report. That was the profile report that was brought to the committee in January. That included all 3 categories. The level of detail in their attrition data, though, I'm not entirely familiar with.
I think personally, unless we have a clear picture of what we're looking at, it would be difficult to set a baseline at this point. Not to mention when we say attrition, certainly we would be a lot more concerned with a school dealing with a high academic related attrition rate than for other reasons. And also my understanding, and maybe this is a common belief one way or another, but typically you would tend to see a higher attrition rate at the end of 1L than 2L, because I think, you know, when students start their second year of law school, things tend to be a lot more stable because now they are acclimated to the school and the environment and the materials. And so logically you would see, you know, a lower attrition rate in the second year than the first year, which seems to be supported by the data that you have just put up.
This is Alex. I agree with the chair just in terms of getting more information behind like the attrition data and just get a little bit more just qualitative before trying to make a decision on that. That's my own personal opinion.
Would it be helpful, though, to call out as a factor without having any particular numbers that we consider when we're assessing the quality of an education program?
Just so I'm clear, Paul, are you suggesting within the rules, just explicitly identify that when assessing like a sound program of
Yeah.
education, that would be
So,
one factor?
Because I think one of the things that's engendered my response to this was running into a program or two that was losing 90% of its 1Ls in, at the end of the first year. And that says to me, some of those people should have been discouraged from attending in the first place because their prospects were dim. And, but that's an outlier. But so if we just leave it, if we make it clear we're looking at that tells the schools, they should keep an eye on that, be prudent about who they admit. And if they become that case I just described, it's clear that we are standing on firm ground when we say, time out, this isn't right, you got to deal with it.
Yeah. Okay.
Do we have a rule currently in place to require the unaccredited law schools to send us this data?
Yeah, so we do gather attrition data as part of our annual report across both law school categories. So this is, that's where that law school performance data comes from. But as I mentioned, we could, in the meantime, explore some opportunities to further enhance that data, whether it's looking beyond the second year or trying to identify some areas for further kind of nuance and color.
But could an accredited law school refuse to give us this data? That is there a rule that requires them a mandate that they report this as part of their compliance reporting?
The rule requires that an annual compliance report be submitted. There is a late fee associated with not submitting in time, so that generally is a motivator. I think, Natalie, you mentioned that I think all of our schools, except for one, have submitted their annual report this year, and we're still engaging that one school. So generally, they're responsive.
So it's a violation of the rule if they don't.
Well, or they could say this is not in the rule. Right? We don't have anything spell out explicitly that they have to provide the attrition rates, or unless I'm mistaken.
Oh, I think the rule probably says they have to provide the annual report on the form that we specify. So it would be better to list all the things we're looking for in our rules. But as we keep adding things that we're interested in, it would also be inconvenient if we had to modify the rule every time we want a new data point.
Yeah, and I'll say on that point, sometimes we're interested in new data and it will be added, but sometimes we get feedback from the law schools themselves that there's data that they'd like for us to explore further. So that does provide some flexibility. Okay. Well, I know this is long. I swear there's only 2 more sections left, but these are important ones. So let's get to this next one here. Again, Dean Frickberg did a wonderful job summarizing our discussion. The next category here was whether or not standardized assessments could be introduced to this law school category. And I think this is an area where there was really robust discussion on this topic. Dean Frickberg mentioned in our staff report, we did reference our former state bar psychometrician Roger Bullis's report, and he found that LSAT is the second strongest predictor of bar exam performance after GPA. Dean Frickberg's right, that did look at our ABA law school population, but the findings are interesting. We did hear from our COAF liaisons that they were in support of this idea. What they had heard from their students and the young people that they speak to and students that they speak to is that a standardized assessment gives a student a real opportunity to understand the opportunities that are available to them. So they've heard from students who, without a score, may choose a certain category of law school, not recognizing that perhaps there's another type of law school that really fits their capabilities. On the other hand, our CS BARS members raised some concerns. I'll summarize those. One of them is accessibility barriers. They mentioned that cost, time, and other burdens that these assessments may put on their unique student population can be a challenge, and it might set back some of our accessibility efforts. There was also a belief that this has mixed predictability value for their students, because they are often non-traditional students. And that's noted in Dean Frickberg's comments. And then I should share too that there was a belief that if the unaccredited law school categories had this requirement, that it should apply to all California law schools. Some members of CS Bars noted that this would be essentially a market disadvantage if one school category was required and others were not. And we shared in our staff report, there have been some recent updates in this space. So the American Bar Association is currently providing variances to law schools to temporarily remove their LSAT requirements. So there's just shifts happening in the space. But on the other hand, there are new offerings that have been brought forward that attempt to address some of these barrier problems and accessibility issues. So we noted there's the JD Next assessment tool, which both is a preparation and an exam folded in one. It costs $299 and it claims to address some of the disparities in traditional standardized assessments. So we wanted to bring this to the committee and share that we've been considering whether or not this category should have some sort of standardized assessment requirement to support enhanced evaluation of prospective students. And so we'd love to hear from the committee whether or not that's of interest and really whether or not they have concerns about this impacting accessibility.
And this is also related indirectly, at least, to attrition, because the goal here is to make sure the schools are making better admissions decisions. Presumably, if they would be eliminating some of the students who were going to fail out before they come in.
Correct. And the way the guidelines for unaccredited schools are written, using an evaluation like this is recommended, but it's not required. I'm sorry, Alex, I think you were going to speak.
I was thinking about that because, again, coming from the graduate business schools space, I've seen a few more schools waive the standardized test, the GMAT, and all those things. So then those schools are relying heavily transcripts or work experience to show their competitiveness for those particular programs. Mm-hmm. And again, I know it's a little bit different, much different in this case. So it puts the burden on the schools to, like what you were talking about, Mr. Kramer, there about, being a signal to the market or, making sure that they're admitting the right type of candidates. So, again, I'm on the other side where we waived the standardized piece to it. So I see both merits in that. So I'm not giving you an answer, but just sort of reflecting on
seeing
that.
the same shifts in the space. So yeah. I agree with you. Okay, well, to be mindful of time, let me just tee up our last point here because I know we've got to get to other points on the agenda. The last consideration really is related to how to roll out these new rules once they're finalized. I think we believe that most of the rules that are included in the proposal really have no operational impact or very minimal operational impact for law schools and essentially can be implemented immediately. Areas where there might be a phase-in period, perhaps for the student complaint policies so that those policies can be created and implemented. Perhaps the law school categories, but I think where this question really comes into play most is the accredited, the NPR. When we had the NPR requirement introduced, there was an immediate reporting period, but enforcement of that really, I think, came at a later date. So I don't know if committee members have any thoughts to share about whether certain rules should be phased in over a certain year period, but this is the last area of consideration for the committee to think. And maybe this is a question that we can revisit once we have a final rule set to bring to the committee.
And Cody, don't we need a notice and comment period as well once these changes been finalized?
Yeah, so the timeline for how the phase-in period should work is kind of separate from the process for approving the rules. So this once it comes back to the committee and is approved, it'll go to the board for public comment, likely 60 days, and then it'll come back to the committee. So that timeline is separate from this kind of
Right.
phase. Yeah.
Yeah, what I'm hoping to do is also look at the public comments and providing additional guidance as far as, you know, whether this grace period or phase-in period makes sense. I think this is what I'm alluding to, but also makes sense that we implement some phase-in period so that the schools can get themselves ready, especially for some of these changes, which would be substantive and pretty major, at least for some of them.
Mhm.
Okay, thank you. For your time, Cody.
Thank you so much for the discussion. I appreciate it.
Thank you, Cody. Unless there's anything else, we are now on agenda item number 5, which is director's report. Audrey will start us off.
Okay, and we do have quite a few slides, but in the interest of time, we're all going to try to go through things thoroughly, yet at a peppy speed. And I'll start. So give me 1 second. Okay. So I didn't share this slide, but you know who we are. So just some housekeeping, a reminder that our January 31st meeting, so the meeting we have now teed up quite a few important issues to actually vote on regarding the work plan and the new California bar exam steering committees, is in person January 31st. So pay attention to emails from Devin about the rooms and what we need to do to get the meeting going in person then. So that'll be great to see everyone. And then in not such good news, we did have a member resignation this week. Just earlier this week, Robert Brody resigned from the Committee of Bar Examiners. So we need to, and we just heard about it right before the meeting. So we need to do some formal recognition in January about his service. He has been a CBE member and a wonderful volunteer for many years. But besides that, we also need to reassign. He was the chair of the examination subcommittee, so we need to reassign that. I know Judge Reyna was the vice chair, so Alex will be reaching out to you to gauge your comfort level in becoming chair. He also had volunteered to help with the bar exam transition to the remote and vendor run test center measure learning to review the contracts with them and to really run some point as a volunteer on diving in deeper with those changes. So that volunteer assignment is also open. So just wanted to let everyone know that news before we get into the meat of the report. I think this is Amy.
Audrey, when's the other in-person meeting this year?
It's the August meeting.
Is it going to be here again in LA, or were you trying for San Francisco?
We were going to try for San Francisco, and Devin, please correct me if I'm wrong, if I'm saying the wrong meeting, but the Jenny Commission has the same dates, I think, booked in Los Angeles. And we have made, not we admissions, but we IT at the State Bar have made some improvements. It's not quite the same setup as you are in right now in LA, but in terms of the Zoom enabling of the room in San Francisco, I think we're going to do some testing to make sure that it would be good in terms of the public being able to hear everything on Zoom from that room. But we're trying to work it out so we can have that meeting in San Francisco.
And that's August, right?
Correct.
So,
When is that meeting in August, the date?
I'm sharing my screen. Does anyone else have it?
Just give me 1 second. I have it posted.
August 22nd.
That's correct.
That's correct. Any other housekeeping?
No, the only thing I would add is for the next meeting in LA, I would ask the staff to help us arrange another, dinner the day before the meeting. It'll be good to see everyone after the holidays.
Oh, that would be great. Let's do it.
I believe that Becky will be presenting this on the first year law student exam. Becky on?
Hello, everybody. I will provide an overview of the October 2024 first-year law student exam. It was administered on October 22nd. The exam was delivered primarily at Prometric testing centers across California. An adjustment for applicants to test remotely were made for out-of-state applicants or those preferring remote testing due to lack of nearby Prometric test center sites. As a reminder, there were some changes to the exam format. The elimination of the essay portion that became effective with the June 2024 administration. So the current exam structure is 100 multiple choice questions administered into 90-minute sessions with a 20-minute break in between. The release results for the June 2024 exam will be today, December 6th at 5 p.m. And the next first-year law students exams will take place on June 24 of 2025. Next slide, please. There was a total of 229 applicants, 167 at Prometric test centers, 62 via online remote testing, 225 used a laptop, 4 applicants wrote the exam by hand. There was a total of 10 no-shows, 4 no-shows at Prometric test center sites, and 6 for remote online testing. As you can see, the majority of applicants selected for laptop use, 225 out of 229. Remote testing accounted for 27% of the total amount of applicants. Higher no-show rate among remote test takers compared to Prometric test takers. And as you can see, we only had 4 applicants who decided to handwrite this examination. As we continue with the examination, we continue to track device usage trends to inform future planning.
Thanks, Becky.
Okay.
Okay, so I'll continue. So we'll be providing the CBE updates on the content validation panels. And so this is our first one. I want to highlight the accomplishments that we've made over the past few months and what's coming up for us. So in September, we held 2 sessions. These 2 sessions were in one weekend session that went over 2 days in San Francisco. And at that time, the content panel reviewed questions, and some of the questions that we reviewed, a portion of these were the ones that were used during the phase 1 of the California Bar Exams Experiment, which we'll be hearing about later. In October, we held 5 days worth of sessions, over 3 sessions, 2 held over a weekend, and 1 was a one-day panel. At that time, we looked at more questions as well as the faculty guide material. And in this case, it included the content maps and the questions. Again, we received feedback on the content map, so we continue to review those. As you can see, in November, we had 2 sessions. One was a weekend day, one was a one-day session. At that point, we reviewed questions as well as feedback that came back from the student and faculty guide material. So we received feedback from the general public, from this panel. That feedback has gone back to Kaplan, and so we plan to republish once we complete a response to the sets of feedback that we received. In December, so this month, and actually it's next weekend, we're going to host another session. We'll be reviewing more questions, and that will definitely put us on target to meet both the February and July 2025 California Bar Administration. That specifically that we will have a sufficient number of questions in our item bank for those exams. Are there any questions? Okay, thank you.
Jody, I believe you're next on agenda item 5.3.
Thank you, Chair. We just wanted to provide a quick update over the last two board meetings, issues that were discussed that are related to the committee's work in the Office of Admissions. So mid-year financial projections were shared with the board in September 2024 with a continued projected budget deficit for the Office of Admissions at $2 million. The law school fee revisions were finalized with some minor adjustments made at the September meeting. And then in November, our team provided an update to the board regarding a variety of topics for the Office of Admissions, both the July 2024 bar exam results, information about the experiment phase 1, report on the question development, and an update on the court order related to the future bar exam. Now,
question. On the November meeting, there was an item, they were talking about the review of the sub-entities. Is it too early to talk about the final results? Because I know there was mention that the bar Board of Legal Specialization might be disbanded and some of its functions would be given to this committee. Where does that stand?
Maybe another member of the team can speak more to that just because I'm not tracking that as closely. I think Amy mentioned it.
I can speak to that. Yes. So at its November meeting, the topic was introduced. And what I mean by that is information was shared with the executive committee about this, and there were no decisions made. So I believe it's going to be on the next agenda for the Board of Trustees, and we'll bring it to the committee at that point because we don't know what the final determination is. What was shared with the committee at that point was preliminary findings from a survey and from interviews conducted with CBLS members, past and present.
Thanks.
Okay. So I know we've talked a lot about different data today. I'm about to go through a lot of numbers, so I'm going to try to just really summarize this with some important top lines. We've done a lot of analysis on various data sources related to the experimental exam. Some of those come directly from the exam platform, others from our own survey data. So I want to just go through those. Just to paint the most important picture of those who attempted to take the exam, we have found that 92% of attendees completed the exam successfully. When we look at the data, just 5% of test takers that attempted the exam faced a technical issue that prevented them from completing. And then when we drill in on that population, what we found is most of them skipped the computer equipment test prior to the exam, and others identified issues with their computer equipment using the test prior to the exam, but didn't resolve them before the exam itself. So we are feeling more strongly that we can mitigate those tech issues through some of the steps I'm about to describe. But I just want to also be responsive to a public comment that we received at the beginning and note that we did receive 497 requests for a testing accommodation for the experimental exam, and 89% were approved or partially approved, which is essentially at par with our acceptance or approval rate for our typical bar exam. So I just wanted to be responsive to that. But let's go to the next slide. As I mentioned, we've really drilled down on what we believe to be the issue that small percent, that 5% of test takers faced, and it's those computer equipment requirements. So what we have done is we've worked with Measure Learning to raise their system requirements for the online test, increasing the RAM minimum, internet speeds, things like that, which we think will reduce some of those tech issues. Maybe even more importantly is that we will be mandating the mock exam and the computer equipment test. We've done that with previous exams that are online. What that means is that a test taker has to check their equipment so they know whether or not their equipment will work prior to the exam. And if not, they have an opportunity to try to resolve the issue because the mandatory mock exam and computer equipment test will be prior to the exam. That was not in place for the experiment, and we think that led to a lot of these exam day issues. Further,
Cody, can I
Yes.
ask a question? Like that last part you mentioned.
Yeah.
How far in advance, or like from the computer check that you recommend or is recommended?
Yeah, Amy, do we have a date set? I'm sorry, I don't know whether we have or Becky, maybe you can speak to that, whether we have the last date for that test to be conducted.
I am
The
not.
mock.
Our mock exam, and yeah, exactly.
Yeah, we'll be tracking it up to the day before the exam, so that Monday.
But when we say
Uh,
mandatory, meaning if the applicant doesn't take the mandatory mock exam, then what happens?
We will have to, well, first of all, we're going to start monitoring it to start sending reminders to alert people that they have to take this exam in order to sit for the actual exam. And then we'll, aside from the reminders, then on that last day, we will have to alert applicants that they won't be able to sit for the exam. And I think that we have to, but they'll have some notification prior to that to give them time to take that exam. Because there's two types of mock exams. So there's one that will be with live proctoring, so that has to be scheduled. And then there's one that is just testing on the platform itself that do not require scheduling.
Great. Yeah, and Amy brought up a good point. So I mentioned we believe that a large majority of the tech issues were the computer equipment. The remaining portion, to some extent, was related to the proctoring software, meaning there's a package that needs to be downloaded to connect with the proctor. And when you take this mandatory mock exam, you'll have to do that prior to exam day. So we think that also kind of addresses those remaining tech issues.
Cody, have you considered, for those who are having technical difficulties or, for example, not having enough RAM or memory, have you considered perhaps setting a deadline for those individuals to either upgrade their memory or get a new computer, such that if they don't do it within a certain time frame or timeline, that they would then be switched over to a different modality, whether it is just at the data center or whatnot? I mean, have you considered any alternative?
I guess I would say to the extent we've considered that has been just tracking our mandatory mock exam and computer equipment test, but I think we could consider further whether we want to follow up with those who need to take some action. I don't know if we've explored that yet.
Yeah, because if we were to do the mandatory mock exam all the way up to the day before, that leaves very little time for any applicants to discover that perhaps their computer is not up to par or does not meet their requirement. That leaves them very little time to find alternatives. So I think we need to think about what, if anything, we could do to alleviate circumstances such as these. I mean, also looking at the statistics, we have more than 100 applicants who know that they have issues but never attempt to resolve them. I mean, that's not a small number, right? We're looking at 140 individuals. If those numbers continue with the actual bar exam, well, I would say that number would be a lot bigger, right? Because now we're looking at a lot more individuals taking the bar than those who have applied to take the experimental exam. And so anyway, the consequences is a lot, it's significant. So again, I would defer you and Amy, as far as what we need to do, but we need to give them enough timeline to find alternatives if somehow they don't pass the mandatory mock exam, for example.
Understood.
Yeah, thank you for that, Chair. I guess that's a decent segue to the last point, which is we are really focusing on enhancing our communications to really prioritize the importance of taking these steps. So that will definitely be a priority for us as we're communicating with our applicants. So let's go to the next slide, because there are just some survey data I want to share, and of course, and like I've mentioned, I want to get through this quickly to be responsive to our time. There's two pieces of data that we've been able to gather related to satisfaction and other input that we've received. One is from Measure Learning themselves, and the other is from our own State Bar survey. We were able to analyze Measure Learning survey data. We found that they asked customer satisfaction questions to 1,864 individuals who completed their exam. So this does not represent those that were unable to complete, but for those who did, 80% were satisfied with ProctorU, which is the proctoring platform, and 88% were satisfied with their proctor themselves, the person who was performing. Many of them cited the convenience, the accessibility, the design of the platform, and there was actually a lot of praise for some of the proctors. Patience, thorough, professional were some of the terms that were used consistently. There was also a separate survey that went to test center applicants, test center test takers, and that's on the next slide. And what we found there was general satisfaction with the test center experience, high satisfaction ratings related to the comfort and the space itself as a test center, the proctor's knowledge and professionalism highly rated, and you can see here just some other questions that were asked, but generally satisfaction was high at the test centers. Perhaps more valuable is our own State Bar survey, because this went out to over 800 applicants who both participated or could not participate, or who attempted to participate but couldn't complete. So this is a more clear picture of the entire eligible test-taking population. I want to note before we get into this, we looked at the demographic data for the survey population, and we found that it very closely mirrors the February and July bar exam test taker populations. So we do feel that the survey data is very representative and valuable as we look towards the exam in February. But what we found was, again, generally high satisfaction rates. There was 68% satisfaction for live remote proctoring as a model, 75% satisfaction for those who tested in person, and 72% satisfaction for those when asked just about computer-based delivery in general, so responding and receiving to questions via computer. And I want to compare that to past surveys, because when we asked for an applicant's overall exam experience in our post-exam survey in July 2024 and July 2023, we found only 38% and 51% satisfaction, respectively. Now, of course,
what was the most common concern across the 22% that have expressed dissatisfaction with the experience?
Yeah, I'm about to get to that in this next slide. So let's go to the next one. I'll be able to describe that. Where we found dissatisfaction was high, understandably, were those who could not complete the exam. While many individuals who had issues had their proctor or tech support resolve it, if you could not complete your exam, 9 out of 10 of those individuals felt dissatisfied with the support they received. And the top reasons for dissatisfaction was that their issue was unresolved. So they had a tech issue, they went to tech support and it wasn't fixed, or long wait times. But I want to note, just to go back to our statement earlier, because we believe so many of the tech issues were related to computer equipment problems, those are issues that really wouldn't have been able to be resolved using tech support. So it's understandable that the top reason is that their issue was not resolved. Now to the next slide. We also tracked exam modality preference. We found that 61% of those who participated in the experience would prefer to take a remote exam for the bar exam in the future. And again, just comparing that to previous surveys in July 2024 when asked that question, bar exam takers, 51% preferred that. And when we asked it in February 2024, 64% preferred that modality. And lastly, I want to just note, we had a question related to the multiple choice questions. And I know the committee is going to hear from the State Bar psychometrician about the performance in closed session, but I will start by saying so far the psychometric analysis looks positive. But we also asked survey applicants about their feelings related to the questions, and the feedback that we received was generally positive. 2/3 agreed the questions were clear and concise. Nearly 3/4 found that the topics were relevant to the materials they studied, and the same found that the question style and format was consistent throughout the exam. So that's the data that we've been gathering, and as I mentioned, we've got a lot of different data sources that we're putting together and looking at to try to make sense of this experiment.
Thank you, Cody. Questions or comments from any member of the CBE?
Evan has her hand up.
I just want to note for the record that Alex Lawrence had to leave the meeting early.
Thank you, Devin. Okay, well, here are none. Thank you, Cody, for the information.
Bridget?
I believe Bridget.
Okay, thank you. So this is just a quick update on some of the items of the fee bill that related to the committee's work. Just generally speaking, the fee bill, it's AB 3279. It did increase the active licensees, attorney's fees or licensing fees to $88. With respect to the committee oversight, it talks about, and this is something I think, Paul, you might have had some specific questions on, but we did pursue some statutory changes to clarify this issue that was in the statute from long ago about the Committee of Bar Examiners regulating non-JD programs. And so we pursued this statutory change and that did end up in the fee bill and was approved. So it just makes it more clear that if you have some of these schools might have a program that has nothing to do with ultimately becoming a lawyer or being leading that you could take the bar exam, that's not something that the CBE is going to consider. And then it does have a specific, there's a statutory requirement that every 7 years we do an evaluation of the bar exam, and recognizing that we will be working on this new bar exam that would have been due in 2025. The statute just gives us an extension on that, if you will. And then there is one other provision that requires us to do a report to the legislature about the number of complaints regarding access issues that we received during bar exams. Beginning in July of 2026 is when we have to start doing that reporting. So that is something that we will start to talk about, how to gather that data and move forward on doing that legislative report. Any questions about that? I know it's fast, but these are kind of the key things that relate to your work.
Correct me if I'm wrong, but one thing I saw in the summary of the bill in the bar's press office was there's a provision now that authorizes appointing authorities to remove people they've appointed if they're, I don't know if they gave specific reasons, but the message I got was, if we're not able to fully participate due to other competing jobs or whatever, that we might find ourselves having to answer whether we should remain on the committee.
There was one, sorry, I don't have it right in front of me, but there was an amendment that does allow the board, I think it relates specifically to the board and the removal of board members for cause. That is something that other licensing agencies have in their statutes, and it was something part of the accountability measures that we were putting into place, trying to be on par with other licensing agencies in that space. But my belief is that it is that particular statute was related to the board specifically, and that was the reason why. Does that sound like what you're talking about, Paul, or are you talking about something different?
Yeah, no, I don't have it in front of me either. I never bothered to look at it.
I'm pretty sure that's what it was. It was part of our accountability measures, and there were a series of amendments that had to do with the Political Reform Act and some other just kind of accountability measures that we were recommending from a governance standpoint that would apply to the state bar, that apply to other state agencies but hadn't been expressly applied to us.
Do you think there's any appetite for loosening the Bagley-Keene rules a little bit so that, because it's going to cost the bar a bunch of money if we have to keep traveling, to its offices because our residences or offices are not ADA compliant?
I can't answer that. I do know there was a bill last year that looked at amending Bagley-Keene, and it did a little bit, but I think it's just kind of a back and forth of efficiency versus public access and transparency kind of conversation. And I don't know the answer to that, to be honest with you. about what the legislature would do. I'm not sure it's something that we as a state bar would pursue, but I can certainly bring it to our legislative team.
Well, yeah, it's a financial drain on the bar.
Yeah.
I'll note that I do not believe we've had any members of the public visit us here in the LA office all day.
Yeah.
I wonder how many people who say that they have ADA access, you know, the remote locations that on the agenda, really do.
Yeah, you don't want to go there.
Any other questions on the fee bill? Okay. Thanks.
That brings us to the last item on the agenda. Cody, back to you. Oh, I'm sorry. I think that concludes it because the last item was the Board of Trustee updates. So with that, I don't believe we have anything else for the open session. Can you please confirm for me, Audrey?
That's good. Everyone should have received calendar invite from me for closed. Hopefully we can just go into closed.
Great. Well, with this concludes our open session. The committee members and the staff, you are now, or please leave the open session and join the closed session, the link that Audrey has sent to you.
We are recessing.
We're in recess and we'll be back after completing our closed session.
Hi, Devin. This is Ashley. I don't know if I got the closed session link actually, so I sent you an email.
Sorry, Ashley, what was that?
I don't think I got the closed session link, or
Oh,
maybe
okay.
I lost it, but I sent you an email.
Let me get it to you. One second.
Thanks. Bye-bye.
No. And we're still waiting for the LA office.
We are.
It looks like LA office is back online.
Okay, we made it in LA.
Good to hear. So the business for the closed sessions is now completed. And I believe we need a motion to recess the meeting until tomorrow at 9 a.m.
So
Do we
moved.
have?
This is Kareem.
Thank you, Mr. Gongora.
Is Alan
Second.
second?
Thank you, Mr. Yokelson. Unless there are any additional questions or debates, Devin, please take the roll.
Dr. Bolton? Dr. Bolton?
Dr. Bolton is left.
Thank you. Dr. Cow?
Same.
Dr. Cow is left.
Alex Chan?
Yes.
Kareem Gangora?
Yes.
Larry Kaplan?
He left.
Paul Kramer?
I'm here, yes.
Alex Lawrence? Esther Lynn? Justice Misiwala? Bethany Peak? Ashley Silva Guzman?
Yes.
Judd Trina? Vince Reyes?
Yes.
Alan Yokelson?
Yes.
Back to Justice Misiwala?
She had to sign off.
Devin, do we have a majority of votes of those members present?
We do not.
Of those present?
Of the members present.
You have an absolute majority of that.
Yeah.
We do.
Thank you.
Everybody voted yes.
We can then recess. Thank you.
The motion to recess passes.
Thank
Thanks,
you.
everybody.
See you all tomorrow at 9 a.m.
Thanks, everyone.
Bye.
Hey, Devin, are we going to have any snacks here in the morning?